morning and welcome to HOA Fight Club. I'm Raylene Schifano. This morning I am going to do a educational series on how to deal with a rogue board. So let's get to the point. I want to share my screen with everyone. All right, so we're going to share my screen and share. All right, if you let's see, we're going to go up to the top. So how to deal with a rogue board. Identifying a rogue board. So most declarations state an HOA or condominium association are established to maintain the common and limited common areas, maintain the architectural integrity of the community, plus create and maintain the harmony of the association members. If the board is refusing to follow those CC&Rs, they may be a rogue board. Any association that does not have a website with the association CC&Rs, financials, information, or will not let the owners come in and see the records, may be a rogue board. If you are being fined and the association board is not offering a hearing or the right to be heard, they may be a rogue board. If the board is using property managers or attorneys to communicate with the members, they may be a rogue board. If the meetings of the board are not open to the members to view, they may be a rogue board. If the board has an attorney on retainer, they may be a rogue board. So I want to talk about that with you guys for a little bit because I know I can identify a rogue board pretty fast, and I think that you guys can too. And I just, are any of these issues that you as homeowners have been going through? I know a couple of you are dealing with issues right now. And do these address those issues? So, I mean, do you guys,
Yeah, I would say for us that definitely in our situation, our board is not following their CC&Rs. They're not doing annual required audits with a independent CPA. They haven't done it for 8 years. And they were not also complying with tax filings. They just did that because, we began to notice and let them know that they weren't doing this. So these are pretty important financial documents that they were not accomplishing.
Well, and one thing that I've noticed working with people that most of the time, I know with one of the callers on here or one of the viewers today has been dealing with an attorney that has denied her access to records. Now, he said that it was because she wasn't a homeowner. So to be considered a homeowner in HOA, you have to be on the title of the title or the deed of the home. So you should always make sure that if you want to participate, I know husband and wives do a lot of stuff, but if your husband, spouse, wife, or whatever is not on the title, they are not really members of the association. So people have to understand that. And this person was added to the title later, and she's done nothing but have to fight for her rights to get to the records. The board should not need an attorney on retainer. They have the rules and the declaration and the bylaws to follow. So the fact that they're using attorneys prior to following the process really bothers me because it's wasting homeowners' money. And we want to make sure as homeowners that the board is managing the association properly, excuse me. Which when I found my board, they were not managing anything properly. They were just making up rules and fining people. And if you go to the county website for King County and you look up my association village on James Street was the name of it, there was pages and pages of liens and foreclosures. So that board had just made everything against the rules, and they fined you. They had one homeowner that was fined because they were Black, and the board wrote that down. And these are the kind of things that are allowed, boards are allowed to do. So, and what makes it even worse is the participants were the board, the property managers, and the attorneys. They had colluded to do all of this. They wrote it in the minutes of the association, never expecting someone like me to come along and read 10 years worth of history. So you got to get those records. And if you don't have the records of the association, that is your first, I think that was the first sign that the board was really rogue, was when I was asking for financials and realized what I needed to ask for, they denied me. And that is always the boards and the attorneys and the property managers, is to deny, delay, deflect. So if you believe your board is not doing what's best for your association, what are your options? I started going to the board meetings, which when I first started back in 2015, asking to go to the board meetings, I wasn't allowed to go into those meetings. They had never allowed, in the 30-year history of the association, they had never allowed homeowners to view the board meetings. So, but when I read the CC&Rs, it said I could come in and view those meetings.
Okay, let's see if I can write a prayer while listening to the Fight Club.
Hi, Cindy, how are you? So anyways, this is what the board allows us to, they wouldn't allow us to participate in. So then the next thing I did was learn my CC&Rs. So, and the law. The one thing that people really don't understand is that the declaration, the bylaws, the rules and regulations of the association, all of those are over the state law. So every time that I get a complaint from a homeowner, the attorneys always quote the state laws first, but they never quote the CC&Rs first. And usually when a homeowner's at the point where they're needing my help, they have already been denied records, they've been denied everything. So being able to quote the declaration and the bylaws really, really helps. And so we want to make sure that we learn those, we learn the laws and how to use them. Whenever I was at a meeting or had an opportunity to speak in front of the board, I would quote the CC&Rs. I would quote the declaration and they would be like, I don't even know what you're talking about. That tells you you're dealing with a rogue board. Your association board, the property manager and the attorney, need to know the laws and the CC&Rs. If they don't, they're in breach of their duty already just by not knowing that. So the next thing that I would do, I would write up a formal complaint listing every declaration and bylaw, rule and regulation that you think the board is in violation of. Every member of the association, and I know it says this in most bylaws, every member of the association is responsible for making sure that everyone follows the CC&Rs. Everything is supposed to be fair and equal. That's how the laws were supposed to be created. We know that that's not true because boards aren't held responsible for their actions and attorney and property managers aren't held responsible. They're all held harmless. The only one that's held responsible is the homeowners. We have to deal with our issues in civil court, which none of us can afford civil court. So I find it very unfair and unbalanced. It's an unbalanced, unfair, and an unjust system. But if you know your CC&Rs in the law, you will be able to fight them with the same thing they're fighting you with. So write that formal complaint, mail it certified letter, and I always mail it to the record of the association. I mail it to the board, the secretary, the property managers, and an attorney if there's one of record. Everybody, even the insurance companies, I mail notifications to if I know who they are, which everybody should know who your insurance company is for the association because they are required by law, I know in Washington state, to have a certificate of insurance issued to the homeowners every year. When I got that certificate of insurance, because I do own a couple corporations, I asked for the full insurance policy because you want to know what they're insuring, not just what they're kind of spelling out on their little certificate of insurance. You want to know the details of what is covered. The next option. So you have the rogue board. The next thing you have to do is get to know your neighbors. The only way to remove a board member or a rogue board is by having a special meeting of the ownership. Now, this may happen. You might be having issues with your association board prior to the annual meeting. At the annual meeting, if there is a quorum, homeowners can make motions. They can motion to remove all board members. They can motion to remove one board member. And I know in Washington state, board members can be removed with or without cause. So you need to know how many people have to be, how many owners have to be there by person or by proxy to get the quorum. And then you have to know how many you need. In some bylaws, it takes 51% of the people to remove the board. no matter what. So even if you have the quorum, some bylaws require 51% of the association to vote out the board member. So know what your meetings require. A special meeting of the ownership can be called. It depends on what your bylaws say. Again, you have to know what your bylaws are and the percentage that it takes to get a quorum. So if you're going to call a special meeting of the ownership and it only requires 5% of the membership to call that meeting, but you need 10 to 20% of the ownership to get a quorum, and then you need 51% to get a vote, you need to make sure that you have all of those three qualifications prior to holding that special meeting of the ownership. I think that those are really high. That is one thing that I want to advocate in the laws, is that having more than 5 or 10% of the owners to call a special meeting of the ownership is really hard to do. And you want to get those. Why do attorneys and property managers not want the homeowners to meet? The reason I came up with was the board never wanted us to meet together because that's how we start talking. That's how homeowners get ideas. That's how they get to know each other and get emails from each other and start participating with each other. And once the people learn that they have the power, that it's really not the board members have the power. If your board is doing all of these things, you need to make sure that you are able to tell the other homeowners what is going on. I was, of course, shamed by a good portion of the homeowners that had been there for all those years. Now, those members were getting special privileges by the board. They were getting their homes taken care of. They weren't getting fined, but people that questioned the board were always getting fined, and our repairs weren't being done. And so you could really see within the meeting minutes that they were now required by law to have, that it wasn't being done fairly. And once I could pull all the meeting minutes together and sit in a room with a judge, the judge saw how they were towards me right off the bat. So we just have to get the news out to our neighbors and friends and call those special meetings. And even if you call a special meeting of the ownership and you aren't successful with removing a board, I always call that as, we're in this big war. We're in an HOA war. Those are little battles that we will win and lose along the way. So the one thing about having a special meeting is at that special meeting, you will meet homeowners that you didn't know in the past. So you want to make sure that you have those meetings no matter what, and never feel defeated. My recall of the board was not successful when I did it, but within 3 months after that, the homeowners were participating and that rogue board was gone within a few months. So it was just getting to that special meeting and the board seeing that the homeowners weren't going to put up with this any longer, scared them enough that they were leaving. They all sold their homes and tried to leave as fast as they could. The one thing about the law in Washington state is if a board is found guilty of doing things maliciously, then they can be held responsible. So I always keep track of everything, every email, every piece of paper, every letter, newsletter for the associations. I know that some boards use newsletters to slander and defame homeowners. They talk about things that they shouldn't be talking about in those newsletters. So always make sure that you are part of the newsletter list and that you participate in reading those and make your comments to the board. Then the next thing I have is learning the Roberts Rules of Order. So I know that there are people trying to recall their boards. The Roberts Rules of Order, and this is what it looks like. It's just a little, I don't know if you guys can see it or not. It's just a little book that gives rules of order for a meeting. This is the book that legislators use. This is a book that's going to tell you how to make motions. It's going to tell you how to second those motions. It's going to tell you how to deal with an annual meeting and a special meeting of the ownership. Now, the one thing that I like about Robert's Rules is it taught me how to make a motion. It taught me when I can make a motion and what you need to follow up with those motions. So let's discuss annual meetings or special meetings. If you're at an annual meeting or a special meeting that has been called to order and has a quorum, a homeowner can stand up and make a motion. You can motion that the owners remove all the board members at that meeting. If you make a motion, you have to have somebody there ready to second that motion. That is one of the most important jobs you can have. So I make a motion. I motion that we remove all the board members. Immediately, somebody has to second that motion, somebody else besides you, so that you can get it to the floor to be discussed. That is the process. So make sure that if you're ready to make a motion, you have somebody that's going to second your motion right behind you so that you can get it to the floor to be discussed. Any motion that is made can be voted on and should be voted on after the discussion of the floor. So you want to make sure that the board knows that you're following Robert's Rules of Order. If there's going to be a special meeting of the ownership, tell them you will go by Robert's Rules of Order, because well, I know in Washington State, it's actually listed that they have to follow Robert's Rules of Order. So that is the way that corporations, nonprofit, all corporations have to run. So make sure you get that. The one thing I took away from Robert's Rules is sometimes the boards get into a habit or a custom of running meetings a certain way, or enforcing the rules in CC&Rs inappropriately and failing to follow the CC&Rs. No matter how long they have been dealing with an established custom, it is, however, it can never conflict with a written rule. And if the conflict is pointed out, the written rule must be followed unless it is amended to incorporate the custom. So the board can't just change the bylaws and the declaration. We had a board that was they had their rules and regulations. They were using those rules and regulations to make up and create things to actually violate homeowners' rights. We owned our garages. I've told this story before. We owned our garages, but the board took it upon themselves to make rules for the garage so that they could fine people for breaking those rules. They made up blind rules. One week it was we could all have our own different color blinds. The next week they said everybody had to change them back to the metal blinds within 2 weeks. So, and they all had to be white. People had just moved in and spent all this money on brand new blinds, and now they had to change them again according to these rules by the board. So they were just picking and choosing. And in the minutes that I found from the board of directors, it showed how the property manager advised them to change the rule, how to find the people, and how he and the attorney would put people into foreclosure using those rules. So we want to make sure that we understand the rules so that you can call the board out. I, at the end, was getting fined. I got fined twice for the use of my garage. The first time I didn't know what due process was when I got fined. The second time I got fined for my garage, I knew what due process was. I knew that I owned my garage and that the board couldn't do what they were doing. It took the board 6 months to finally get it to a due process hearing just to be heard by the board, because I had called attorneys in and everybody else to protect myself and my investment. These are our biggest investments of a lifetime, and we cannot have a rogue board running around foreclosing us or fining on us into foreclosure. That is why I had the laws changed this last year in Washington State, that boards cannot use late fees, percentage rates, attorney fees, or any other things to put people into foreclosure. They can only apply liens for past due assessments. Now, because most people don't know that that law changed this year, those boards and attorneys are still going to try to do so. So I always suggest everybody make sure that you go to a housing counselor in Washington State. If you're past due on your assessments, you can go to these housing counselors for free. Representative Orwell and Walsh worked really hard at changing that law so that the consumers and homeowners of Washington State could be protected. If you're not in Washington State, you need to be asking your legislators some questions. The association board does not have a right to ignore the declaration or the bylaws, the rules and the operations procedures, which I know there are homeowners associations that have operation procedures. They cannot violate or exclude the rights established in these covenants. To amend these covenants, the association must follow the rules established by the bylaws. The declaration and the bylaws usually require over 67 to 90% vote of the membership to approve. I have found associations that have changed these covenants and get away with it without holding the meeting, because the membership is complacent and they allow for this board to do what they do. And until they stop it, it will continue. You have to notify everybody you know in your state to make sure that they know. The Secretary of State, I sent notifications to, the Attorney General, I sent them to. I was talking to people in the Secretary of State's office, every person I possibly could. How can you have a licensed corporation that has all these special privileges to put people into foreclosure? In Washington state, we can't sign away our constitutional rights. So that is really important, that you call your legislators and demand that no law shall be passed. And those special acts that they've created, the nonprofit one, the HOA laws, the RCW 6438, 6432, 6434, and 6490 are all unconstitutional acts because they violate your constitutional rights. We need to hold our legislators responsible. And I do have a lot of legislators that are ready to make a change. HOA and condos are these associations are corporations. They have volunteer boards, they have professional management and attorneys, and these are all required to follow the covenants. It is your duty to make sure that the board members understand that you will not allow them to violate your rights and your rights as a member of the corporation. The only meetings, let's go down after, get all my emotions out because I get so angry for you people that are still stuck in HOA. So I want to take a deep breath here, because these are corporations, but they should be ran as corporations. They shouldn't be ran with our emotions and our the boards that don't allow you to participate in this are violating your homeowners' rights. They're violating the declaration and the bylaws. If you have a board that is fighting to stay on as a volunteer, they have done something they do not want the owners to see. There are red flags everywhere if a board is not allowing you to participate. Our board, before I moved in 2014, begged homeowners to be on the board. They could not get anyone to come to the meetings. They could not get anyone to serve on the board. But the one person that wanted to be on the board, they wouldn't let me on. They would never let me on they cheated in all the elections because I was one of the only homeowners that was actually nominated by its members and never got to be on the board because they didn't want me to see what they had done. Unfortunately, what the board didn't realize is that I'd already seen most of it. I had gotten into the boxes of the association. So you have to hold people responsible. You have to participate. That's the only way you're going to require changes in these. I spent years, and my legal fees were over $68,000 trying to get these unfair and illegal people thrown out of their position of power. Again, I held a recall of the board, but I wasn't successful at the time. But I didn't know the rules at the time. I didn't know how or what. Those of you that are going to initiate a recall of the board, please go to your county website. And I always go to the tax assessor's website because the tax assessor has everybody's that is an owner on the title. They have them listed, and you can type in your association and all of them will come up. One thing that boards do is they use your lack of knowledge of who lives in the association. They will take those addresses and they will know who's going to show up to the meetings and who's not there at the meetings. And they can say they have proxies for the people that did not show. Make sure that you have a checklist at the door when you walk in, when homeowners walk into that special meeting to recall a board, that you can compare with the board's checklist, because every homeowner should have to sign into that meeting that is there. So they have proof of the quorum and they have proof of the membership's votes. So those are very important things that you need to require when you're at those meetings. Everything that happens at a meeting has to be recorded, whether it's by video or whether it's in the notes. Make sure that the board is doing that. But a special meeting of the ownership to recall the board requires the homeowners recalling the board to be responsible and knowledgeable. You have to know who's coming to that meeting. if a board member's husband or wife comes to the meeting and they are not on the title, they really aren't allowed in that meeting. Property managers are not allowed in special meetings of the owners. Attorneys, unless they've been announced, cannot come to those meetings. Those special meetings are for the owner's membership only. It is for the members to be making decisions, not for boards to control the meeting, not for property managers and attorneys, but for everybody else to have a voice. That is your meeting to have that voice. So make sure that you know what your rights are before you go to that meeting. Make sure that you know who's coming to that meeting and what their intentions are. It's really, really important. And then at the end of the day, you have to ask your legislators how they're protecting homeowners. I've asked mine. I sent them my letter asking why they've given the corporations and the property manager and the attorneys an express lane to foreclosure for homeowners. No wonder we have so many homeowners in the United States. We're allowing boards and attorneys to unethically, unlawfully, and unconstitutionally take away our homes without any due process and without the right to be heard. So I suggest everybody call their legislators and make sure that we're holding them responsible for the laws they're creating for us. Do I have questions?
Can I say something? You can see that the looks like the bar, like a car bar, is protecting the attorneys instead of public interest in housing, in HOA housing. How can you deal with that?
Well, the one thing that I found with dealing with when you turn an attorney over to the bar doesn't want to get involved. They don't want any responsibility. They always try, you got to remember the bar is just attorneys. They're attorneys judging other attorneys. If they made it real easy for us, the common people, to make complaints, and they would be taking our side. So they're not going to do that unless they have a reason to do it. Now, with your situation, the one thing that I do know is that the attorney is no longer participating in any of the communications, which means you've done something or something has happened that has taken him out. He has realized that he is violating the laws and you have called him on it and I have called him on it. So that is why he's gone quiet. Now, you know, maybe he has a different feeling about things. Maybe he was wrong and he's embarrassed and he doesn't want to say anything. I did have a community that, you know, thought that the association had retained an attorney. The attorney says that they were never retained and that wasn't their opinion. So I think attorneys need to start being held, if they're held responsible for their actions, they seem to back away from everything that they're doing wrong. So when you sent that attorney in for ethics violations, he's backed away because he knows that he's going to get caught in the long run doing, well, he admitted he did it wrong. So in his own emails, he admitted that he violated your rights as a homeowner. So
I didn't realize that.
Yeah, well, he did because he said that you're okay, you're right. She is on the title, right? He finally admitted you were on the title, and it didn't matter whether you were on the title or not because you were the homeowner's representative. You were the homeowner's proxy. So whether you were an owner or a manager, you had the right in your state to get those records, and he denied them unlawfully. So he's been taken out. He's not participating. He's not battling you. Now you need to figure out whether you need to start getting onto the property management company. You need to turn them over to the Better Business Bureau. You need to, you know, make complaints that are going to show that they're not following the law. One thing I always say is be professional. Never use your emotions to write letters. What I do is I go through and I write a letter. I put all my emotions in it, and then I go back and I read it and I take all of those emotions out because it makes me feel good. It's therapeutic to write those letters and put everything that I'm mad about in them. But then you have to go back and look about, you know, am I being a professional? I always say you shouldn't say anything bad about the board personally. the one thing I never did with my board, I never talked about them, their personal lives, what they're doing personally. I never said anything bad about them as a person. Where on the other hand, they were sending out emails telling people that I was a horrible mother and that I should be, that I was a horrible business owner and I was horrible to children. And I ran a business with children. I'm a gymnastics coach owner. That's what I do for a living. I'm not an HOA fighter. Back then, I was just a gymnastics coach. I owned a gymnastics club in the state of Washington. I only do what I do now because of what they did to me. So those attorneys and those property managers, which it was more than just one, there was 5 or 6 attorneys and 5 or 6 property management companies and over 20 people that had served on the board in the time that I was there. That's how many times everything turned over once I started finding out who was violating the laws. I ended up, being the winner in the long run. Now, is it winning? I don't feel like I won because this changed my entire life. This made me start a nonprofit. This made me start talking and speaking up for homeowners. The one thing about being a business owner in the city that I was in is I had a voice. I already had a following. So to make me look like a crazy person, the board and the attorneys couldn't do it. So you want to make sure that, and I went to the news. If anybody is doing this, you need to hold your news reporters responsible in your state. Email them and ask them why they're not doing news stories on HOA that actually will help people. You know what my news story said? Yeah, we know that they're unconstitutional laws, but the Attorney General says we can't change them because they're already done. No, those are special acts that were added to the laws. There's lots of things, and legislators should be held under the Civil Rights Act in 1983. Legislators that make unconstitutional laws should be held liable for those actions. So we could actually start pushing as a nation to have our legislators that do not want to protect your constitutional rights and your property rights, we could have them prosecuted. And, there's a lot of things that need to go into this, but we need to become Washington State has an army now that are going to come in and testify against the legislators for these laws. So if anybody's in Washington State that can show me what these associations have done to benefit its members, I would like to see it, because I think foreclosing on people is unconstitutional. I do feel like you should pay your association dues. I think that if you're past due on your assessments, you should seek help. But I want to make sure that those assessments are properly applied to our accounts, to people's accounts. And those that do fall into lien and foreclosure, that they have help, that they know that they're being advised right, and that there is somebody overlooking. We need accountability and governance over these associations. These are corporations that have to be licensed by law. So let's make sure our legislators are backing those requirements so that we don't have to deal with special recalls of the board. Nobody should have to pay attorneys and property managers to recall a board, because those attorneys and property managers should be holding the boards accountable for their actions. They should be our first line of defense. And that is the kind of laws I'm going to require to be done in Washington State, not the ones that allow for people to be foreclosed on with no due process.
Maylene, I have a specific question. This
Okay.
is Sherry Stacy. So when we call a special meeting and we do have a quorum and we are able to, the way our bylaws work, we have to have a 10% quorum to call that meeting, which is, how we enacted that was a petition. And we use wet signatures, people that we, knock on doors and say hello, and friends of ours who are neighbors who are interested in helping us. So then when we get to that meeting and we do have then a 20% quorum that's required to do business, can we call that meeting to order without the board if they are not there, if they refuse to come?
The board refusing to come would be a breach of their duty. So especially if if you've given the proper notice,
Yeah.
I know your situation. I would have another meeting just because of what they're trying to say, but the board not showing up to a meeting, it takes the board to call the meeting to order because they are the board of directors. But if the homeowners, then boards could just stay outside and they wouldn't have to ever do their duties. So if the meeting is given proper notice and the notices are sent out and the board doesn't show to that special meeting that has been done right, then the board should be able to, the homeowners should be able to rally together and call that meeting to an order and vote the board out. I would make sure that I had the signatures of the homeowners, make sure that you had the proper quorum, do everything in writing. I would record the whole meeting. Washington State, homeowners can come by electronic means, so they don't actually have to show up. So I would suggest that you have a Zoom call option for those homeowners so that you have a link that they can join or some other sort of a meeting thing. You want as many members to show up as you possibly can, whether by Zoom or in person or by proxy. Watch those proxies though. That's the key right there to, when I went back and found, I found that there was a bunch of proxies that had been forged by the ex-board president. So because she knew everybody in the neighborhood, she'd been finding them for years. So that, you really have to watch the membership and who's coming into that meeting, make sure they're members.
Right. And then if they're coming, maybe just have them show an ID, and then you have a list of the members who could vote because they're on the landowner list.
Yeah. So, and like I said, there was a gentleman in our community that was dating a board member. So he wasn't married to her even, and he showed up at the special recall of the board. And I had him escorted out by the board. You cannot have anyone that's not a member of the association there. Now, some association bylaws do allow for, your spouse to be there. So, but you have to be married contractually. So, you just have to know what your bylaws say. It's really the details are in the words. I have an association where, they add things to the rules, well, it has to be done this way. No, it says it specifically has to be done this way. And I always remind people that if the declaration bylaws or the laws say shall means they must do it. They must do it that way, word for word. There is no interpretation. Yet if it says may, the board has the right to interpret those ones that say may. So know the difference between the two. No law shall be passed. That's Washington State. No law shall be passed that is not fair for everybody. So Washington State has a really good chance this year of, if the homeowners show up and testify, we can kill every bill on the floor the day of. So I killed like 2 or 3 bills on the floor, and it was
happy to come with you.
Yeah, it was just me testifying. But what I made our legislators realize is that taking a home is cruel and unusual punishment. I mean, it was quoted that way. It is cruel and unusual punishment. We've had legislators in our state that fight for the rights of marriage. And Senator Peterson said it then, we shouldn't have to fight for one person at a time. And I always say we shouldn't have to fight for one homeowner at a time. The laws should have the way to protect the homeowners. The CAIs and these trades groups should have nonprofits that help homeowners. Where's their attorneys that are volunteering to help homeowners that can't afford attorneys? An attorney's ethic code, and I want all of you to remember, their code of ethics requires them, if they see failures in the law, that they should seek better improvements to the law, not take advantage of it for profit. And that's what they've done with these laws. They've taken the condo and HOA laws and learned how to take advantage of them for profit. CAI, the trades group or nonprofit, they say they're a nonprofit. They actually say in their bylaws that no member should be a profiteering person. Well, that's all we have is profiteering people that work under the guise of we're helping an association. They did a survey, CAI did a survey, and it came out and it said that 67% of homeowners are happy with their associations.
But that's not true.
I had to laugh, but they're using that survey to take your homes. So if you don't know who you're fighting against, which you're fighting against a mob-like corporation that is taking people's homes for profit. They're lobbying to take your homes. They're lobbying they're lobbying to take them non-judicially, which means without court, without due process. They are lobbying to take everything you have, your businesses, your homes, everything. How does that help homeowners? I have those questions, and I can't get anybody from CAI to answer those questions. And up until this last year, I couldn't get the legislators to answer those questions. Now they're answering them. I have, like I said, Representative Orwell, Senator Kaiser, Karen Kaiser just joined the group. She lives in a condo association, and she's done with it too. There's so many legislators that live in HOAs and condos, and they don't even know the laws they voted into place. How are we supposed to be able to understand the laws if our legislators can't understand the laws or don't understand the laws they're putting into place? How do they expect the common people to be able to read all these CC&Rs? They're made for attorneys. They're not made for us. They're not made for a gymnastics coach owner. They're made for the attorneys and the property managers to take advantage of the laws for profit. And that's all they're made for. They're not made for the homeowners. So any other questions, Sherry?
Yeah, I'm sorry.
No, you're.
Yeah, so in our case, it's obvious that this attorney helped to forge this contract that wasn't there 3 years ago. I was thinking if we can find the attorney in a way so that we know that when we go to court with HOA or the property management company, and then we already have a legal standing of, okay, somebody is already wrong on this case.
Well, Teresa, you know what else I would do? You can actually put in an appeal for your complaint to I know you've been emailing the office of this Tiffany person. I would send an appeal to the address. I think it was in San Francisco.
Yeah.
I would send an appeal to them and show them the evidence that you have of this forgery. You're not trying to protect it for you and your case. You're trying to protect the entire association, which was his job to do in the first place. But
Right.
he didn't do it to protect the association. He was doing it to benefit and profit from the association. So when an attorney defends a client, they have to do what's in the best interest of the client. So if the HOA denied your rights, that said no, or that the board shall give you the records of the association, he knew when he started that he was violating the law and the CC&Rs. That's what makes him unethical, because he doesn't know his job. His job, the first ethical rule of professional conduct is that he should know his job. He should know that if the law says shall, that he shall do it. So he violated that law. He violated that ethic. So you need to appeal it and send him in for that and go from there. That's where I would go next if I was you. Don't go to the Tiffany, go to the other person, the other address listed for San Francisco on that paperwork. That is what I did. I went in because somebody has to protect homeowners. Somebody has to protect the association. If the board and the property managers and the attorneys are not willing to protect that association, the homeowners have to. That's the law. We have to protect our association. Allowing a board to get away with this kind of stuff is allowing them to violate the laws. So hold them accountable. That's the only thing we can do, is hold them accountable and fight for the laws to change as a group. If we have an army behind us that is saying, okay, we want changes, that a bill of rights for homeowners, we want property managers, attorneys, and boards to be held responsible. The homeowners are held responsible. If we're wrong, we lose our homes. If the board is wrong, they're held harmless. How is that fair and equal? So I had to do so much research. George Sarpoli was a huge influence in my research. He made sense. His writings made sense to me. I never read the Washington State Constitution prior to being in an HOA. Now that I've read it, I know that we have rights that the legislators are in violation of by creating these laws. So I think that it's just because it's just one of me this year. But one of me changed the laws this year. One of me helped change the nonprofit laws. One of me helped, so that we could have electronic communications. There's so many things that just one of me did, that think about what 10 of us could do or 100 of us could do. I think we could really make a difference in Washington state for the homeowners. And if one state makes these laws changes, another state will make them, and another state will, they will all fall in line. The one thing about the bills that I've done, they've all been voted for bipartisan. The Republicans and Democrats all understand that it doesn't matter what your political beliefs are. It matters what your, what you believe for your home. So we're all being violated. All of our rights are being violated, whether you're Republican or Democrat in these associations, and it should stop. So we have to speak out.
Yes, agreed.
Go ahead, Sherry.
No,
Yeah.
I just feel I appreciate all that you have been doing for us homeowners, and it's made a difference since I looked through the new laws myself, just going through this, and encouraging people to do research and to know your neighbors is just a real powerful way to not only just make a difference in your homeowners association, but to make a difference in your community, to grow community, and to have the ability to, one of my members who was talking to me last night, and she was just saying, we just have so many plans that we want to do for this community. We want to have community gardens. We want to have, meetings where we can talk about emergency safety and all these things that aren't being done. And we feel that we can make not only just a difference in our HOA by, participating in a special meeting and recalling the board, but that we can also make a difference in doing this by bringing wonderful, powerful ideas and agendas to our community that will make it a better community.
Well, it will. And one thing about a board, if they're not allowing the homeowners to come in and voice their, first of all, in Washington state, you have the right to voice your opinion at every board meeting, whether it's prior or after. The board has to give you an open meeting time to have discussions with the board openly with the members. And, they don't want to speak in. I found that when I started going door to door and meeting my neighbors, I met so many amazing people. My best friend was living in I met her and we became best friends. She ended up working for me. I'm her godmother to her children. Now I had seniors excuse me, that were having a hard time getting to their doctor's appointments, and my schedule where I had employees, I could schedule around the seniors' doctor's appointments, and I was going to every doctor visit with the seniors. I became the community. I was the one that brought it together. I mean, I would have homeowners stop at my home and leave me flowers.
How wonderful.
They would knock on the door and say, thank you. I just got goosebumps. Just remembering that, how much I had, I get flowers from people in Chicago for helping them. And, it's just, people are at their wits' end by the time they get to me. So if you're at their, and that's what I tell the legislators, we can't fight this alone. I'm the only one that's doing this for free for people, and that's not how the laws should be. The laws should be to protect the homeowners, protect our investments. And, if you're using it to pay for attorneys, how is that protecting our investment? If you have an attorney on payroll, how does that protect your investments? We're finding ourselves into foreclosure. We're allowing boards to find us into foreclosure using these attorneys, and the attorneys need conflict. So the only reason they're there or they have a job is because they've created a conflict. Denying Teresa the financials of the association caused conflict. And the only one who benefited from that conflict was the attorney. That was it. The homeowners association still had to pay the attorney bills. So did the homeowner who pays those assessments to that association. When I got in, I found that they were spending $38,000 on attorneys, and we only had $13,000 worth of assessments past due. Why would that board not make payment arrangements with those people and work with those people instead of it'd been better for them just to pay off the people's past due assessments. So you have to look at both sides as a board. Now, the attorneys and property managers, of course, they think foreclosure is better because that's how they profit. That's how they make money. When an attorney doesn't have to follow fair collection laws and he can add $2,000 to $3,000 to your account in a day just for doing a letter to you, that's unlawful. So those are the things that we need to show our legislators of how these laws have caused our constitutional rights to be taken away. And, it just, we have to fight as one. We can't fight as 20 different groups that never get anywhere, because also, if you're on Facebook and you're just talking about HOA and you're not out trying to make a difference, it's never going to change. So you have to become like me. I had the tenacity to not take no for an answer. And my dad used to tell me that as a little girl. What about no, don't you understand? Well, this is why I was brought up that way. So is to question everything. We look at our nation right now. It's in chaos because of the political, the political people are trying to get the people to fight amongst themselves. That's the exact thing that HOA does. It tries to get the homeowners to fight amongst themselves and not to communicate with their neighbors. And that is how you destroy a nation. And that is how you keep control of the people in your community, is by not letting them talk. So make sure you're talking to your neighbors, know who those neighbors are. So when they show up at a meeting, you can walk around and say hi to everyone, know them by name. Every person that would drive by my house in the neighborhood, I would wave to them. I was the sweetest, kindest person, which is my personality anyways. But I wanted every neighbor to know that they could come to my door and I would help them. And they did.
And that's powerful. And I think that, in our neighborhood, we're finding that. And one of the things that I took on as my motto, I suppose, is the old Texas Ranger motto. It says, no man in the wrong can stand up against a fellow that's in the right, and keeps on a coming. And that's what we're doing. We're all committed in our little HOA here to keep on a coming. We're not going to stop. We're going to keep on going until we get the a board that will follow the state laws for nonprofits. And they have made rules that we cannot ask any board member a question in the meeting. They will not allow us to do that, but we can make a comment. And now they've made a rule that if we write a comment, it will not be read into the meeting minutes. It can only go to the board later to be read. So the only way that we can even have a voice in a board meeting is to have a verbal comment. And I'm trying to help people to stand up and make those verbal comments. And I see people on this meeting who have done that, and I thank them.
Yeah.
So
you should remind in your anything that you do, you need to remind the homeowners that the board is in violation of people don't know that the RCW 6490 actually has laws in it that pertain to HOAs, not just to the 6490 code. One of them is the 6490 for meetings. That applies to all associations now. So you want to make sure that you understand what that means, because being, part of that was that the homeowners have to have the right to be heard before the board meetings. They have to have the right of notification to every board meeting and the agenda that is going to happen at that board meeting. So if your board's not communicating and you live in Washington State, you need to just start quoting those laws to them. I like what you guys are doing. I like that you went out and got to know your neighbors. I think that and you did go by the bylaws and the CC&Rs, Sherry, that said 5 days. The state of Washington has done a lot of changes in notifications. So those never supersede the bylaws. But out of courtesy, you're going to allow that to happen, which means the homeowners have already made an adjustment for this board not showing up once. So if they don't show again, they're really not interested in what the homeowners have to say, and they should be removed. So just call it appropriately and stick to the rules, and always quote the CC&Rs. I would go through the declaration, the bylaws, and the laws and pick out what they're violating. So when you guys have this meeting, you'll be able to state what they're doing is in violation, because there'll be people that try to question everything you do. Sherry, another thing I want to give you an advice on is the board tried to limit our time. So when we came into the board meeting, they gave us rules. And one of the rules was each homeowner that spoke only got 3 minutes to speak.
That's
Same
what they're
thing
doing
here.
to us too.
Okay, so here's what you do. So Sherry, you stand up, you give, or whoever's going to go first, you give the spiel. And if you run out of your 3 minutes, the next person to stand up, you need to have somebody stand up and say, I motion that my 3 minutes are given to Sherry Stacy. And somebody seconds it, they have to do that. They have to allow you to speak. And if every homeowner gives one person their 3 minutes, first of all, they're going to show that they're on board with you. And second of all, there's not added confusion. Now, the other option you could do is, Sherry, you produce 3 minutes of a spiel and the next person has it and you go in line and you know what you're each going to say for those 3 minutes. But members can give their 3 minutes time to another member by motioning that member has a, and if you guys want, you can just have somebody stand up and motion that Sherry gets a half hour to speak. On behalf of the
Sherry
homeowner.
doesn't need a half an hour.
I could speak all day.
Yeah. Well, I guess I could take a half an hour, but I think I would be succinct enough to
Yeah. It
cover
doesn't
what we
take
needed.
long to say what I have to say. Look, you guys are following the rules, period. These are the ones that you're not following. This is why we want you out. This is why we called the meeting. But there will be emotions. There's at our recall, they had hired an off-duty officer. I didn't know then what I know now. So of course I didn't know that they can't have an officer at the meeting. They're not members. Now they might be able to stand outside, but they cannot be in that meeting. That is a members only meeting. So you really want to make sure that it's stressed that this is for members only. Anybody that is not on the title or the deed or a member, or not with a member, then they will be asked to leave. So the property manager shouldn't even be there for the special meeting of the ownership. They're not a member.
That's always good to know.
Well, it's just, it's those little details though. Look, the board's already, if the board has a property manager there, they're already violating the CC&Rs. The special meetings are of the members, not of property managers. Now, board meetings are different. They need somebody that's telling them about contracts and all this other stuff. But meetings of the ownership, the annual meeting and the special meetings should be of the ownership. They're meetings of the ownership only, not of the property managers to be able to shrug off. The reason the board's not communicating with you is because they want to be held harmless. So if the property manager is doing the communicating, the property manager can blame the board and the board can blame the property manager, and then they're both held harmless. So they're not communicating, and you need to demand as a homeowner that your board communicate with you. They are your leaders, not a property manager, not an attorney. The board, you have a right to speak to the board directly. And that's why you're allowed to go to each of the board meetings and have a voice. So if they're not doing that, they're violating the law. And that's another thing. So if we start turning these corporations into, especially Washington State, into the legislators, if you call your legislator, whoever that is they're going to know me by name. So call them up and tell them that you want me to represent the homeowners and that you want that legislator to listen to me. That'll help.
How do you find them? I have no idea how to find them, the contact.
You should be able to go to your whatever district you're in, Charissa, in your state, and I actually have a 1-800 number. I'll have to find it. You can type in the 1-800 number and it'll text you back who your legislators are for who you should call.
Okay.
So one thing, like I said, one thing I did was I took the legislators of Washington State. I went to the site and I copied and pasted every email, and I made my own email list to the legislators. And if anybody in Washington State wants that legislator email list, I will share it with you. And then, so when I go to create an email to my legislator, I copy all of them on it. So
I want to do the same.
Every single legislator is getting an email from me, educating them on HOA and what it's doing to our community. Washington State has a lot of people in foreclosure, and there's going to be so many in foreclosure after the pandemic stuff ends. And they won't lose their homes to their mortgage. They're going to lose their homes to their HOA way before they lose their homes to their mortgage. So, that's what happened in 2007, 2008. If you go back and look at the county websites, you'll see a lot of foreclosures and liens during that time, because the boards were taking advantage of it, and they were advised to do so by the property management companies. I have it in there that Targa Real Estate, I mean, it was in the minutes that they had told the board exactly what to do. And then they had a condo law attorney that was, backing their foreclosures. All done in Washington State. You have to be 6 months past due prior to to being in foreclosure. What they were doing was they would take that, $500, or our HOA dues were about $500 a month, and they would, charge that, but they would add the attorney fees on right away. So that puts you into foreclosure right away. You're already 6 months past due. So they can't do that anymore in Washington State. Now,
But
homeowners don't know that, and the attorneys are going to take advantage of it until they get caught.
yeah, excuse me. What do they do with your home if, after the foreclosure? How do they benefit from that?
Well, so here's what happens, and here's what was happening in our community was the board would put a lien on your home and they would foreclose non-judicially. They would auction off the home in a sheriff's sale. The association, the board, would buy back that home without the homeowners knowing it. So they would use our assessments and our to fix up the home. They would rent the home out until the mortgage foreclosed on it. So it's not like tax law. So tax law, if you get a foreclosure in tax law, the taxes, so they sell off your home, they sell the home, and then they pay off the tax debt, and then they give you the balance of what was profited from the home. That's not how they do it in HOA. You still owe your mortgage company, even though the association now owns your home. So you're in foreclosure either way. So that's another thing that I'm going to talk to the legislators. It should be done as the tax law. If they're going to put a lien and foreclose on a home, that home should be sold, the HOA paid off, and then the homeowner should get those funds, the option to repurchase the home or to move away, but they should get the funds from that sale of that home. They should not be stuck with a past due mortgage that will get to, so now they'll have two foreclosures, one from the association and one from the mortgage. And that ruins their credit. Now they can't get a job. Now they can't do anything in the state because they have, they're in bankruptcy pretty much because they lost their home. So they're, that affects your credit. So to protect the homeowners, we have to do more than that. We can't just make it so easy that, these people can just foreclose for any reason. And the attorneys are really at fault for these laws of foreclosure. That is the one thing that these lobbyists really lobby for, is the right to foreclose non-judicially. They do not want to have to go to court. They do not want to have to prove anything. They just want to take your home in 90 days and make $2,000 to $3,000 per home. That's if it goes easy. If the foreclosure isn't fought and they just get to foreclose, yeah, they only make $2,000 or $3,000. But if a homeowner fights them, now they're making $20,000 from the association, and the association still only makes they don't make any money off of the deal unless they sell the home out from the homeowner and make a profit from it. So, which they're not doing. They're just using your dues to rent out the homes most of the time. And you don't even know, you're not getting the financials to be able to tell where that money is going. We found that my board was actually with the property manager. They were commingling funds, and the property manager was pushing the funds out to two other nonprofits. And those two nonprofits were ran by the board of directors, individuals from the board of directors. So, if homeowners don't know where their money's going, they can't make a complaint. And yet that's the first thing that we're denied is the financials. I don't want to see a property manager spreadsheet. I want to see the actual financials. I want to see the bank statements. We have a right to see bank statements. Property managers aren't FDIC insured, so they should not be handling money. It should be going into a direct deposit, and the homeowner should have a right to see those deposit records. They should be able to see who's past due. They don't have to see the names of the people past due, but they should know how many people are past due. So they have a voice on whether we should foreclose on those people or whether we should help those people. So it's just, I'm just I want to be fair. That's all I want is fairness. So
Yeah.
people don't lose their homes. And it's really, really important for us to require the fairness.
One more question.
All right.
Like our HOA, when we had the plumbing project for 220,000, that contractor was not licensed at the time he entered the contract. He started the job, but he didn't even have a contract. They made up the contract later. But in many states, that if you are not a licensed contractor, you should not get paid for more than $500. Now, if they get paid for $100,000, like 2 years later, after they get the license, that's what happens, this Andy.
And there's every person that is on your property has to be licensed. They have to be bonded. They have to be insured. I mean, every contractor has to have a contract. Every contractor there should have been 3 bids put out to 3 different contractors, and the board decides which one's better. If your association's using the same person to fix everything at one contractor, I usually find there's a conflict of interest. They're usually owned by the property management company, or they are a brother or a relative of somebody that a board member. There's always a conflict of interest, especially when they're not licensed and bonded. It's the board's job to make sure that everybody on that property is licensed and insured. It's required by the declaration and the bylaws that they have to be insured. They have to have workers' comp. They have to have every sort of insurance. So you're doing what's right, Tris, and that's why they're not answering you. You're calling them on things that they don't want to share because it will jeopardize their position. And you're in such a small community. It's so hard. And it's so hard for people that are in communities that have thousands of homeowners. How do we get contact with thousands of homeowners? I only had 130 homeowners to contact, and that was hard enough. So how do homeowners have that opportunity to know their neighbors when there's thousands of us in these, in these associations? So it's
my concern is the board, the president of the board. He left this complex. He sold his home in March and left, but he was the one caused all this problem. And
now you know why he left.
Why he left? But can we still get him responsible and fine him, because he was the one hired this unlicensed person? And he was.
When you're dealing with contractors and property managers and attorneys, the only people that can sue those contractors and attorneys and property managers is the association. So the association board would have to vote to go after those people. Now, because those people are represented by the property managers and the attorneys, and there's a conflict of interest there, they usually will advise boards not to go after these contractors and these property managers and that, because there's such a conflict of interest. And they don't want anybody, the property managers and attorneys don't want us to become awake and aware of what's going on in our communities. So it's just better to deny, until we give up. So they just deny until you give up. The one thing that they aren't counting on is for you to become educated and to not give up. You have to be a thorn in everybody's side. What I found is property managers that were serving the board, every time I could, all the complaints I was making and everything, they knew were true. So they could either go along with those complaints and stop the board, or they could quit and move on. And most of them would quit and move on because they didn't want to be held responsible with the board. So hold them responsible, keep sending those certified letters, let them know that you're not going to sit back and take it. If you have to go hand out a letter to every single address, that's what it takes. That's what it.
No, I have no problem doing that. Yeah. My question is, if the president of the previous board left the place, a complex, let's say if I go get on the board next year, can I sue the previous director of the board who already left?
If you have the vote of the board, yes, you can.
Okay.
So there's probably a time frame. It's usually 3 to 6 years in contract law. So yes, you can go after a previous board member, but it would be the association that would have to go after that board member.
I have to be on the board first. I have to
You have
become
to be on
the
the,
board.
yeah, you have to be on the board, and you would have to have the vote of the board to do it.
Mhm.
So you'd have to have all their votes. And if you guys are in an association that's using an attorney, I would ask for the meeting minutes that showed that they had, they voted to put or to use this attorney, because anything the board does requires a vote. Everything has to be done in a meeting. So the board can meet outside of a meeting, but they can't conduct any business. So even in their executive meetings, they can discuss things, but they have to vote in front of the people. They still have to come to a board meeting and vote in front of the people. So they have to take a vote to hire an attorney, to actually go after homeowners, or they have to vote to put people into foreclosure. So every lien in foreclosure takes a vote of the board. So you need to make sure that people understand that it's not the property managers and attorneys that are doing this. It's the vote of the board. The board is held responsible for everything. Every decision they make is their decision. Whether the attorney made that decision or the property manager, the board is held liable for those decisions. So if they're wrong decisions and you can prove that they're wrong, then prove it. Prove it to them, the attorney, the property manager, the insurance company, send them certified letters and prove what you are stating. I send it to the Attorney General, and I also send it to the Secretary of State. I used to CC the Attorney General on every email I wrote to the board members and to the property managers. To probably the Attorney General, probably he never blocked me. So, but they knew. I mean, the legislators knew. I would CC them on the emails I was sending. So that's why property managers started quitting. CC people on there. CC your legislators on your complaints. CC everyone you know. CC me, CC other homeowners. The one thing that I had the advantage of was I had 40 to 50 homeowners that were on the emails with me. So any email I put, the homeowners were chiming in right behind me. So the board had no control anymore, and the property managers just kept quitting because they couldn't, they knew that they were going to be held responsible if I sued them. And I didn't sue forever because I didn't want to hurt the homeowners. That's the reason it took me so long to sue my association. Was I
That's
knew
exactly what I'm having the problem too.
Yeah, it's really hard because these are your friends and your family. So I always tell the people, first of all, call your insurance company and get special assessment insurance. I had $50,000 on my condo insurance or homeowners insurance. And I had that special assessment insurance in case there was ever a special assessment charged by the association. And then I always have, I have an umbrella policy on me that will cover me in case somebody decides to come after me for any reason, but, I had to learn that I had to protect myself in the meantime, which we shouldn't have to worry about. We're homeowners. We're just, consumers. Why is this one thing okay to take advantage of consumers on? This is our biggest investment, and the laws make it so easy to take it from us. And that's the legislators' fault. They should be more held responsible for the laws they pass. And this is one of them that I'm going to hold ours responsible for. So does anybody else have any questions?
Thank you so much, Raylene, just for sharing all your experiences and
Yeah.
just how we can work through the law.
Yeah. And like I say, just call me. You guys are doing what you can. It takes an army, and so we have to build. And, whether you win or lose your recalls or it's difficult, just always be professional. The board, most boards will go low. So expect them to go low and to talk about you personally, and you're have personal reasons for this. I just take the high road all the time. Look, I appreciate that, but this is business. I'm trying to keep my emotions out of it. Even though this is your sanctuary, you try to be very professional, and you will be successful if you are professional. And just take care of your homeowners, and they'll understand. Even those that hated me at the end didn't hate me so bad. And they were the ones that had to pay the price. I mean, because, like I said, my association had to buy back my condo at full asking price and pay pain and suffering. And in Washington state, in HOA, pain and suffering isn't common at all. Washington state doesn't offer pain and suffering. They don't offer tort damages for homeowners that are suffering under these associations. So that's why the attorneys don't want to take the homeowner side, is because they have more option, or the better chance of losing than the attorney on the HOA side that gets paid no matter what. So, and Teresa, like you said, I do have attorneys that I use that are not HOA attorneys. The attorney that I used, Elena Garella, was not an HOA attorney. And she knows that if she has questions, that she can always call me. Ha Dow in Seattle, I've worked with both of those ladies, and they understand the problems that homeowners are dealing with. So
they all do. When I call the attorneys, they all know what's the problem, but they don't want to take my case because they know that.
Because you have no damages, is what they're going to say. So if you go to court, you have to have actual damages in HOA and condo associations. You can't just take people to court because they're not giving you the financial records, because there's no damages. What damages did you incur, they say. So the damages are they're foreclosing on other people's homes. Those are our damages, but we have to be able to prove those damages. So it's really an unfair and unjust system, and we have to keep fighting it, and then it'll make a change. We're seeing leaps and bounds. So and that's, like I said, just because they had me doing legislation this last session, we will take control if we as homeowners can stick together and fight this together. So that's what I suggest you do. And Teresa, I do have somebody that I'm going to send you her email because she lives in California and she wants to join your cause. So
wonderful.
Just the people that know me, I'll end up putting people in touch. So you'll get your own little army, I promise.
Great. Yeah. I want to do exactly what you are doing, help homeowners, because I'm a real estate broker for 30 years. And the HOA is supposed to help people to get lower cost because they are together, right?
Yeah. Have you ever seen anybody vote to lower your dues?
Yeah.
It's not going to happen.
I have a HOA that keep the HOA low for 20 years. They have ways. That's why I started, don't have to be going up every other year or two. There are people who can do better, but very few.
The first thing you look at is your attorney fees. Take the attorney fees of the association. And I used to divide everything out. So if you're paying $80,000 a year for cable in your association, divide that by each homeowner that is paying. When you start seeing what you're paying for, we were paying $80 a month in our assessments to have cable. And it was only costing the association was only costing them $25 a month. So I was paying $80 a month where I could have had it. It was just stupid. It was stupid. Bulk contracts and all that kind of stuff. Cable companies are all participating in taking advantage of homeowners. So I know there's one in Florida that's having a huge issue with it. So you just have to know what's going on and demand it, and it's really hard. So keep fighting everyone. We'll get this. We're making leaps and bounds. So and if you guys have any questions or anything, you can send me an email. I will post the link for this so everybody can watch it. I think it's really important that people need to know that there are rogue boards out there. Not every association has them, but what to look for and how to deal with them in the end, so that you can have your association be what it's meant to be, which is to increase your property values and protect the harmony and the architecture of the association. Manage those common areas. You're not supposed to be managing the homeowners. So talk to your legislators and give them a call. Does anybody else have any questions?
Thank you.
All right.
Thank you.
Thank you so much for your guys' participation, and I will see you on the next one. Have a good day.
Thank you. You too.
You too.